Welcome to the Kentucky Auto Accident Podcast. Louisville attorney Jim Desmond has been handling injury cases related to traffic accidents for over 20 years. Jim will provide valuable information to help you and your family. He wants you to understand the important issues you need to know when it comes to handling car accidents and motorcycle wrecks in Kentucky. There's a lot riding on this, so let's get started. Welcome to episode 8 of the Kentucky Auto Accident Podcast with Jim Desmond of the Desmond Law Office here in Louisville. We're going to pick up on a continuation of the conversation we had in episode 7 with guest host, attorney Scott Scheynost. Scott focuses his practice primarily in the area of workers' comp, while Jim Desmond covers mostly automobile accident claims and other personal injury. So with that being said, let's go ahead and rejoin the conversation, and I'll turn the mic back over to Jim Desmond.
Thank you, Jim. We were talking. Well, let me go back here for a second because I want to kind of make something clear. In car wrecks, a lot of times I always say that it's a fishing expedition because if you listen to the first episodes, it's about who has how much insurance, are they insured, is the vehicle insured, is the driver insured? Because really, it's a crapshoot. You can basically get hit by a 1980 Chevette and we're in a whole lot of trouble, even if you have a great case otherwise. In workers' comp, one of the things that should be coming clear from the last episode is there's a lot more options. There's a lot more benefits available. But again, on that basis, I think you need to talk to somebody who does primarily workers' compensation law because it's a vast area. I do want to pull up, Scott and I talked a minute about a case earlier we had together where I actually stepped out real fast. But it's very illustrative of everything we just talked about in the last episode, where an injured person was actually killed while working on at a car lot by another employee, who was moving a vehicle. And basically, I had to throw that case over to Scott because, again, it was governed pretty much exclusively by workers' compensation law. So in other words, everything that we talk about normally with uninsured and underinsured wasn't coming into play. But Scott, you remember that case better than I do because it's been too long. But give that as an illustration because we talked earlier about how the employer had immunity, and as well as the employee who was at fault might have that as well. So expand on that a little bit, just because I think it's a great starting point.
Yeah, those are real sad cases involving those fatalities. Unfortunately, they do happen. And if it did happen at work, then of course it probably is work related. And one of our jobs as attorneys is to make sure we try to recover all the sources of income or damages that might be available for somebody. Like you mentioned earlier, the crapshoot. First of all, in workers' compensation, when there's a fatality, workers' comp is going to pay for all the immediate medical expenses, ambulance, hospital, all that kind of stuff. Then there's
let me jump in. Will it pay for funeral expenses?
Not specifically. The old law in Kentucky required that, but they amended it a couple of years ago. And what they do now is they give you a lump sum that the actual amount changes every year. Right now, it's about $85,000. It's just a lump sum death benefit, which goes to the estate. In addition to that,
let me cut you off again. I'm sorry, but you see, this is fascinating to me because some of this stuff I haven't heard before. On that lump sum benefit, is that limited? So, let's say if I'm earning $10 an hour, and God forbid somebody kills me or whatever, is my estate going to recover less from workers' comp than if I was, making, $250,000 a year?
In general, workers' comp benefits are based on how much money you're making. For instance, if you're making more, you're usually going to get more workers' comp benefits. Probably the only exception to that's the death benefit. When somebody is killed at work, there's a specific death benefit, and that dollar amount goes to the estate. It doesn't matter if you're the CEO of one of the biggest companies in Kentucky or if you're, a laborer. That death benefit goes to the estate. So that's probably the only exception to the rule that your benefits are based on how much money you're making. Now, in addition to that death benefit that goes to your estate, though, there are benefits that are based on how much money you're making. For instance, your dependents, if you're married and you have a spouse, if you have minor children, if you have children that are adults that are not able to take care of themselves or disabled, those dependents can get money based on how much money you were making. Then we go back to the average weekly wage, and again, their benefits depend on how much money you were getting. So the more money you're getting, the more money they're going to get. But the specific death benefit, which goes to the estate, which is really designed to pay for the funeral expenses, That is just a set amount. It varies from one year to another. It's supposed to go up according to the cost of living. But the other benefits that the other dependents might get, that depends on the average weekly wage.
Okay. I want to use the death benefit you just mentioned just for an example for a quick second. So right now, am I hearing you right? It's 80 or 85,000 is a max?
Yeah, I'm sorry. I don't know the exact amount this year. It changed 3 weeks ago, and I
okay. No worries. No worries on that.
But it's around $85,000, if not a little bit more. And that'll probably go up next year as long as there's an increase in the cost of living.
Well, and I want to make a point to people because, I think in that regard, we both work on what we call contingency fees, which is you don't owe us any money unless we recover something. So in my case, if it's a typical car wreck against an at-fault party, I'm charging usually a 1/3 pre-litigation, maybe 40% if it goes to a lawsuit. Workers' comp, as I understand it, limits the attorney's fees.
Right.
And I think it needs to be clear that it's not even as much as the 1/3. So let's say you recover a death benefit for someone. Explain that to them.
Well, workers' comp benefits of any kind are limited as far as the attorney's fees. There's a specific statute. The attorney fee can be no more than 20% of what's recovered with a maximum of $18,000. And there's actually a couple of steps in there that may make the percentage even less than 20% before you get up to the $18,000. And I don't want to make this too complicated. But excuse me, the important thing to remember is that an attorney can never charge more than $18,000 for a workers' compensation claim in Kentucky.
Okay. And the other thing that I guess I want to make clear, but it should be clear, is again, attorney fees really aren't charged off medical bills. So it's not like somebody's going to go in the hole over if I go hire you as a workers' comp attorney, it's not going to put me in the hole, and I'm not going to end up owing more from the whole situation.
Correct. We're only allowed to charge fee on the actual monetary benefits that are given to folks. For instance, if we file a workers' compensation claim, and in that claim they give somebody the right to have a surgery, that surgery might cost $200,000. I've seen that happen before. That is not part of the amount we base our fee on. Our fee is based on solely the amount that you actually receive as the injured worker.
Okay. Let's talk about the typical car wreck, because we've talked so far about the extremes where, there's no recovery or somebody has immunity because they're a fellow employee. But, where I deal with this a lot is somebody will be driving down Shelbyville Road and they'll be rear-ended, and that will be somebody who is a sales rep, for example, for a company. So on my point of view, let's go back to the previous episodes. We're dealing with their no-fault coverage, okay, which I'm going to come back to because it's secondary, but the no-fault coverage to get some medical bills and lost wages paid. We're dealing with the liability claim against the person who rear-ended them, okay, that's the third-party claim. And if that person doesn't have enough insurance or no insurance, we could be dealing with the uninsured or underinsured coverage that I've preached about having on your own policy. But where it comes into play for Scott is I'll look at that case and say, well, as Scott made clear earlier, workers' comp is primary over no-fault coverage to cover the medical bills. So I might call him and say, hey, Scott, will you do me a favor and take a look at this police report and see, is there a claim here for you to be able to handle? And you might jump in, Scott, and tell us what determines that.
Well, again, course and scope of employment is a big thing. For a sales rep, it's going to be probably a little bit more broadly defined than somebody else that's been told to go down the street and pick up a tarp or something for the employer. But somebody that has to drive around for a living, generally, they're going to be all over the place. And if they're during regular work hours, performing the regular duties, and they're going from one spot, say one sales call to another, there's not much doubt that's going to be work related for the sales rep. The question comes up when somebody has what we call a deviation from the course of employment. They're supposed to go to point A after going to point B, but they decide to go to the post office in between, and they're going to the post office to send out a check for a bill. That doesn't have any relation to work. So is that trip to the post office related to work? And we'll have to look at how much of a deviation that is. For instance, if the post office is right off the route and they just pull in there and they throw it into the mail slot and go, that's probably not a substantial deviation. If the post office requires them to go 20 miles out of the way when they were only going to make an original trip of 10 miles, that's probably substantial enough to where it's not part of the work-related injury. But during work, you're going to have all kinds of deviation. You're going to go get something to eat for lunch. You're going to have to make a restroom break at some time. There's all kinds of things that come up. Those things are generally covered. The more unrelated it is to your job, the more likely it's not going to be considered part of your job. If you are working and you decide to go to another town 20 miles away because they've got a sale on golf equipment, that's probably a substantial deviation that's not going to be covered. But again, if you are driving from Paducah to Owensboro, you stop at a rest area along the way and you decide to get a bite to eat, and something happens there at the restaurant, that's probably work related.
And Scott and I talked about this too, because Scott will do car wrecks too as well. Let's say there is that deviation and workers' comp gets to say, hey, we're off the hook. You did too much of something else. Then we're going to look back to other sources to recover from. Again, the no fault then would kick in and be primary for your lost wages as well as your medical bills up to $10,000. And then potentially we could even use your health insurance if that gets exhausted. So it is one of those situations where people could have a remedy. Agreed?
I agree. Yeah, you want to look at everything that might be available, and that's probably one of our biggest jobs as an attorney is to see what might be out there to pay somebody's damages. And I'm actually amazed at the number of people that don't even realize they have uninsured or underinsured motorist coverage. A lot of folks don't even know they've got that coverage. They've been paying for it for 30 years.
I tell people to have at least $100,000 per person of uninsured and underinsured on their own automobile. And even if you're driving for a company, I would still do that because, again, well, two things, I guess. One, I've seen situations where, of course, I can go against the company's vehicle and they may have, good coverage where we don't even have to involve yours. And then two, if it's a really horrendous accident, we might still go back to your own insurance coverage. There's probably an exclusion under a commercial vehicle use and all this other stuff, but we can still look and see and try to make our arguments.
Yeah. Hey, I guess I need to tell everybody my dad's an insurance agent, but my experience is that you cannot have enough insurance.
I agree.
You may not be able to pay for it all, but you can never have too much insurance.
Well, and on that issue a little bit, I always tell people, and this is getting a little off, but don't have the rental car coverage. I say leave that off, increase the deductible on the car, but that uninsured and underinsured, and you mentioned added PIP earlier, those are the three that protect you when you're not at fault, and they're huge.
Yeah, and even umbrella coverage and things like that, I've had friends where that's come into play in certain situations. So again, you can't have enough insurance. You may have a hard time paying for it, but you can never have too much.
Let's go back to the sales rep thing for a second, because I know the other thing that employers will try to do to see that make workers' comp not apply is they'll say you're an independent contractor.
Yeah, that's always a good argument for the employer to try to get out of paying workers' comp benefits. And just because they say that doesn't necessarily mean it's true. You have to look at what's going on here, and usually it's the control over the employee. It's seen commonly in people that work in construction trades where the employer doesn't want to take taxes out. They don't want to pay for workers' comp insurance and a couple of things like that. They call the guy that's, basically labor. He's a contractor. We're going to do a 1099. We're not going to take any wages out. That's probably wrong. If the employer is telling somebody what to do, when to do it, how to do it, they're using the employer's tools. It's a job that's typically not one that's an independent contractor, for instance, a laborer as opposed to somebody that might be a plumber. That's typically not going to be considered an independent contractor, even though the employer has classified you as that. And in Kentucky, even if the employer has failed to get workers' compensation insurance and they call you an independent contractor when you're not, there's a government agency that will pay your workers' compensation benefits, the Kentucky Uninsured Employers Fund. Which means that if you are considered an independent contractor and you have a workers' comp claim and it's been turned down, it's probably still worthwhile to talk to an attorney to make sure it doesn't fall into some of these exceptions we just talked about. But I see that a lot. We were talking about sales rep. I think a lot of those are considered independent contractors. Again, it's a control over the employee. If you're driving a company car, well, that's a pretty good indication that you're actually an employee of the company. If the company's telling you where to go, when to go, who to see, what to sell, you're probably an employee of the company. But it's basically the control over somebody. That's what we look at, not necessarily what the taxes say.
And to pull this point out from something you just said, so, and I've seen this before, if I have somebody who's injured and they're allegedly not only an independent contractor, but their employer doesn't have, allegedly workers' comp, you're saying there is a fund out there that they can still potentially go for, that you can go for basically as an experienced attorney and say, hey, you still have to pay my guy's medical bills.
Right. It's the Kentucky Uninsured Employers Fund, similar to what you probably deal with the Kentucky Insurance Guarantee Association when people don't have the automobile insurance in a PIP accident. It's a little bit more complicated than just making an application. They generally aren't required to pay anything till you've gone through an actual workers' comp claim and prove that you were an employee. But it's out there. Some states don't have that. And usually we've got a couple of cases going on every year with them because it's pretty common for people to be either misclassified or have an employer that doesn't have workers' comp. In fact, a lot of times I see people that aren't getting workers' comp benefits and they're talking about their employer. And I think probably most of the time, or a lot of time when that occurs, is because the employer doesn't have workers' comp.
And I just saw this actually. I'm not finishing the case. Another attorney is taking it over because of different circumstances. He and I worked out something that's fine. But the short story again, the at-fault driver, $25,000 in coverage. The person that was injured, $80,000 in medical bills, no uninsured coverage, no underinsured coverage, no workers' comp coverage. So again, basically I was able to assist on the liability portion, the at-fault driver's coverage. And then at this point, this attorney has taken over the workers' comp claim to make, an ongoing claim with it.
Yeah, the best thing about workers' comp is that it pays for your medical expenses. And there's not a limit on the medical expenses that it has to pay for. So if you have an injury because of work, a car accident, and you have catastrophic injuries and you may be disabled and require significant medical treatment for the rest of your life, workers' comp would be responsible for that medical treatment. There's no cap on the actual money they have to pay for medical treatment. There are caps on almost any other type of insurance that you get.
And to expand on that and bring it back to what we talked about with the typical car wreck of a sales rep being hit. So if I'm handling the third party case, I'm making a claim against basically the at-fault, the insurance company for the at-fault driver. And at that same time, Scott can be handling a workers' compensation case where his goal is to get the medical bills paid by the employer. Ultimately, if there's a permanent impairment, then he's saying in addition to that, he can get an award under workers' comp.
Correct.
I'm saying on my end, if there's a permanent impairment, then I'm taking that to make a claim against the at-fault driver, their insurance, and get as much as I can for my client. If I maximize or hit the limits of that, hit the limits of the liability insurance, then again, we're looking for underinsured coverage as well. But to be clear, that when somebody's in a car wreck, and if they're an employee at the time, you really have two separate and independent claims. And that's, again, why I say, that's why I don't even just say, that's why I do. That's why Scott and I, have worked together over the years because, again, we have, different areas that we kind of concentrate in, and they pretty much complement each other if you do it right.
Right. And again, it seems like sometimes my biggest job is to try to find damages that might be able to be paid by different sources. And if you're at work, it's important to realize that you've got workers' compensation available. It seems like a lot of people don't really realize that. Earlier, I think we were also talking about company executives that are traveling. I've been involved in some of those cases before. For those individuals, probably they may have other sources of insurance, their own sickness and accident policies, significant health insurance policies. That's probably a little bit better than the normal workers. Sometimes the medical expenses in those are the main reason to pursue a case. But company executives are probably going to be hit by something. I remember having a case with one time. They were really amazed at what the limits are sometimes in workers' compensation. There's no limit in the amount of medical expenses that are paid, but there are limits on the other sources of income. For instance, what we call temporary total disability benefits, TTD, the money you get for being off work. In Kentucky, there's a limit of 2/3 of your average weekly wage for that. And then there's also a cap that's about $900 this year. So if you're a company executive and you're making $5,000, 2/3 of that would normally be about $3,300. You're not going to get $3,300 from workers' comp. You're going to get about $900. And in those situations, then you may be able to get the PIP to pay for some of the difference. Hopefully, the executive's got his own insurance and added PIP and maybe sickness and accident disability that might be able to throw in there. But I've dealt with some company executives, and they were actually amazed at how little money they were going to get. But there's a lot of built-in caps in the money in workers' comp. There's built-in caps on the weekly amount for TTD. There's built-in caps on the length of time you can get it for permanent disability. There's other caps that are built into it, too, on the amount that you get for permanent disability.
Scott, let me jump in on you on that because I'm kind of curious. And yes, you hit on the nose, of course, with the PIP possibly covering what the lost wages, if the full amount's not covered by workers' comp. But one thing I've always kind of tried to say, too, a little bit is, when I preach about the uninsured and underinsured, it follows you outside the state. So let's say we have an employee from Yum that travels to Colorado, okay? Right. And they're traveling for business, no issues, okay? First of all, everything under Kentucky workers' comp, I assume, is following them to Colorado. Is that correct or not?
Actually, it probably does if they're principally working in Kentucky, and also they may have Colorado workers' comp that might be available to them, and that's just kind of a weird situation for traveling employees. If you're injured at a specific site, the law of that site probably also applies. In addition, you might have the law apply from the place that you normally work from, for say Kentucky. So in that situation, Kentucky and Colorado might apply. You might be able to get the best benefits of both states.
What do you do? Because of course, as attorneys, we're licensed by state,
Right.
so we can't practice outside certain areas. So, what would you do in that situation?
Well, I know what the law is in Kentucky, and I can give them advice on what they would be able to receive in Kentucky, but I do not know what the law is for workers' compensation benefits in Colorado, and I would advise them to talk to somebody that does.
But you could co-counsel with somebody out there, can't you?
We could work that out, yes. My experience has generally been Kentucky has a little bit better workers' comp benefits than most other states. Illinois is probably being the only one that comes to mind that probably has a little bit better benefits. So in most of the situations, usually dealing with a person myself because they've been told by the other attorney in the other state, we don't pay as much here. We don't have lifetime medical expenses. We don't pay for some of the things that you get in Kentucky. So most of the time when it's an out-of-state case, it still ends up being a Kentucky case because Kentucky benefits are a little bit better. There are some exceptions to that, but the bottom line is if you are injured out of state and you've got two different states' laws applying, you need to talk to attorneys that are admitted to practice in both states to figure that out.
Scott, does it have anything to do with where the company is physically located? If the company is headquartered in Kentucky, maybe I'm a truck driver and I'm in an accident or something in Tennessee on the job. Can you make a claim to pull that back to Kentucky?
You can. There's a specific statute, we call it extraterritorial jurisdiction, that deals with that lists the requirements to make it a Kentucky case. One of the big ones is where you're hired at, okay? Where you work from is another one. Without getting too boring here with the details of this complicated statute, it could be covered by Kentucky if the principal business, the headquarters are here in Kentucky. It generally would require that person to work from these premises or at least be hired here. But this is a fairly complicated statute with about 4 or 5 different subsections. And you probably need to sit down and talk to somebody to see exactly if your situation applies. But if you're working from Kentucky and injured out of state, if you work primarily in Kentucky, if you have an office in Kentucky, if you work from your home out of Kentucky and you travel across the country, if you were hired in Kentucky as a truck driver, but you drive all over the country, those are usually Kentucky cases.
Well, and Scott, let me ask you a quick question. Are you licensed in more than Kentucky or just Kentucky?
I'm licensed to practice in Kentucky and in Indiana. I do.
Well, you do Indiana workers' comp, and I'm asking this for a reason, people, because Indiana workers' comp, I understand, is lousy, and it is very hard to find an attorney who will handle Indiana workers' comp.
That's true, and my advice to anybody that's injured in Indiana is to try to find a way to make it a Kentucky workers' comp claim. I'm licensed to practice in Indiana, but I don't have a substantial workers' compensation practice in Indiana. It's a different system. They have people that are not attorneys that are the hearing officers that decide cases. The employer can tell you where to go for medical treatment. And when that happens, they're generally going to send you to the doctor that's not going to do much for you or help you out. And there's a lot of other things in Indiana. You don't get lifetime medical benefits. The benefits compared to Kentucky are generally a lot worse for injured individuals unless you have just a minor injury that results in a small impairment rating. In those situations, you may end up getting a little bit more in Indiana than you would in Kentucky. But in almost every situation, it's better to have a Kentucky workers' comp claim than an Indiana case.
Gotcha. Let me go back to something that's the most common thing because Jim Ray's giving me a signal. We only got a little bit over 5 minutes left. The other part of a claim, okay, so let's go back to the typical car wreck claim where your medical bills have been paid by workers' comp. You guys have heard me talk before about a subrogation claim, and that basically means that the individual, or more correctly, the company that paid the medical bills have a right to get their money back. So in our cases, what happens is workers' comp asserts basically a subrogation claim and says, hey, we paid this money for medical bills or lost income, and we want our money back. Now, from a personal injury side, what will happen many times is you'll see a total settlement. Let me give you, you'll see one settlement where, and I'll throw out figures, a $30,000 settlement with an attorney's fee, costs coming out, and then a pretty good amount going back for that workers' comp lien. And you'll wonder why that has to happen. You'll say, why is it coming out of your settlement? Well, it's not. The whole liability carrier is really considering the whole picture, the big picture. The part that I was going to get Scott to comment on is how much is the workers' comp entitled to recover back? And the reason we go there with this is one that actually other attorneys will probably pay attention to, because we try to make this podcast more toward the consumer questions, but they change this law all the time. Where I really want to say every 2 or 3 years, somebody's calling me and saying, well, what's the new law on this? And it gets complicated to the point where, again, I don't even want to keep up with it anymore. So, Scott, we got a case, workers' comp is asserting a lien. They say we paid $15,000, and we want our $15,000 back. How much are they actually entitled to back from your settlement?
Well, it depends on a lot of things. First of all, it depends on when your injury occurred. Because like you said, the law changed, and I think the last change was about the middle of July 2018. So before July 2018, it was based on what you got. It was based on what your attorney's fees in the third-party case were. It was based on your expenses. And in kind of a weird situation, the more your attorney got, the less the other side got, the subrogation claim was. So if your attorney's lien and expenses exceeded the amount of the subrogation claim from workers' compensation, it was actually extinguished. So in big cases, sometimes, if you had an attorney with $1 million case that got a third of that $330,000, if there was a $200,000 lien from workers' comp, that actually got extinguished. Now, that all changed in about the middle of 2018. Like I said, in July, they passed a new law. The new law is based more on a pro rata use of expenses and attorney's fees. And I'll be flat out honest with you. I've not had a chance to go through that new law in detail. I've not had anybody really with a subrogation claim where that new law applies. But it's more of a friendlier law to the workers' compensation insurance company that's designed for them to get a pro rata distribution. Essentially, the attorney's fees and expenses are considered. I think those are deducted from the workers' compensation lien. And what happens is now the workers' comp carrier has more authority to get a subrogation claim and get more money. Some of these cases, especially the bigger ones, probably would have been wiped out before the law changed. Now they have a better claim for one. And that law is still being interpreted, and I'm unaware of any actual case decisions that have gone down from the courts yet regarding it. But the bottom line is now the workers' compensation insurance carrier is going to be able to recover more. That was the whole purpose of the law, as I understand it, was giving them that right to recover where they were getting shut out before. Now they've got their foot in the door. There's still a lot of arguments, though. If your attorney incurred a lot of cost, if there's a lot of litigation expenses, if the major element of your claim is pain and suffering, for instance, workers' comp doesn't have a subrogation claim on that. So I don't think that's been really determined on how we're going to figure those things out. If a jury has to come up with a decision on that, if a judge has to come up with a decision on that, some of this can actually be done in a workers' compensation setting. I think it's a little bit of a flux, but I almost guarantee you the workers' comp carrier is going to get more money than they did before 2018.
Scott, to clarify, though, workers' comp is going to pay, ideally, the medical bills. They're not asking the victim, the injured party, to pay back their medical bills. This is funds that are over and above all of that, correct? As far as the subrogation goes?
They're trying, the way let's look at it from the workers' compensation insurance carrier's standpoint. We paid this money out. Now somebody else, this third party, is going to pay the person we paid. We want to get repaid too. So they're not looking to actually recover it from the injured worker. They're looking to recover this from the party that caused the injuries to the injured worker. And not only is the workers' comp carrier going to be doing this, but if the health insurance carrier got involved in this, they're going to be wanting to do that. Sometimes you have PIP subrogation claims that come out and all this stuff. Anybody that's paid any money out is going to have an interest in this. There's a big company out in LaGrange, Kentucky that specializes in doing nothing but trying to recover this money. We won't name them, but there's a lot of people that might be listening to this podcast that are probably affected by this too.
I'm laughing because I'm familiar with the company too, and
yeah,
I don't care for them. But
and it's kind of a shame because most people that are injured at work are not going to become big millionaires can buy the island in the Caribbean. There's a lot of built-in limits on what you get in workers' comp as far as the money. And to have another company try to decrease the money they might be able to get from an accident, to me, is just almost criminal. But that's my view. I try to help people that get hurt. I don't try to help the insurance companies. I'm sure the insurance executives have a different view on it. But
and along those same lines, I'll tell people again. I mean, and I'm sure Scott's the same way. Pick up the phone and call us and ask questions because, as Scott's describing this, I'm sitting here thinking the average consumer. Again, if you were handling your own car wreck case and you wanted to do that, that's fine. You've got 3 different sources. You got to make sure it didn't pay any medical bills. Right. You've got to settle what we call exclusive of the PIP lien, meaning the no-fault carrier that has to be paid back separately from your settlement. You got to make sure your health insurance hasn't paid any medical bills because, again, they have a subrogation claim. And again, if you were working at the time or anything else, you got to make sure that you don't have a workers' comp claim that could potentially get your money back or money out of your settlement. And to clarify something and to expand on what Scott said earlier, and I know a lot of good insurance adjusters. I like a lot of them. But again, as he said earlier on the workers' comp side, and I've said before, the job of an insurance company is not to advise you as to all your legal rights. So their job is to get the claim settled and move on to the next one.
Settled as cheaply as possible.
Exactly.
Yeah.
And so, again, it's a situation where, they come to you, and this is what I want you to always be careful about. If you do ever decide to handle your own claim, which I don't agree with, but somebody comes to you and says, okay, well, we'll settle your car wreck claim for $8,000, and you think you're doing a good job saving an attorney's fee. Well, you didn't realize, your employer might have a right to recover what they paid or the health insurance. And so that settlement is really not as good as you think it is, or you could end up having to pay somebody back 6 months to a year after that.
Right. This is going to get real complicated with the subrogation. I've yet to have many clients, unless they actually worked in the insurance industry, understand what subrogation was. And the bigger the case is, the more people that have subrogation claims, some of them what we call super liens, like with Medicare, CMS, and some of those agencies, and you can actually get in significant legal trouble if those aren't taken care of. But that's a real complicated area. It's in a flux, like you said earlier. It's changing. Even though it changed in 2018, we're not real sure what all the changes are yet. There's probably going to be some cases come through the next year or two that will give us a little bit more definition. And by the time that happens, they're probably going to change the law again. So it doesn't hurt to talk to an attorney, and I sure wouldn't want to handle a subrogation claim unless I was an attorney.
Yeah, and the thing that you just mentioned about changing again, and you brought up Medicare being a super lien, that's the part that kind of goes against common sense, and people need to understand that, is that I understand you think Medicare is not involved, they didn't pay my medical bills. Well, not only do insurance companies want to see that, but in the same respect, subrogation, again, goes a little bit against the normal consumer's understanding, which is, if I'm paying health insurance liens or somebody paid it under workers' comp, why would they have a right to get it out of my settlement? Well, the law, as I always say, endeavors to be fair, but it doesn't succeed. So the bottom line on this, again, if I'm in a situation where I've got a workers' comp case involved, I'm going to call Scott because, that's his ballgame. He knows that area. So again, whether it's workers' comp for him or automobile accidents for me, pick up the phone. Don't take the chance. It's not worth the headaches. It's not worth the possibility that somebody could knock on your door 2 years later. So,
well, Jim, with that being said, if somebody does decide to pick up the phone, how can they get in touch with you?
I prefer my cell phone more than anything else, which is 502-609-7657. If they want to send me an email, it's jdesmondatty@yahoo.com, or the website is attorneydesmond.com, and I think I don't know my Facebook page. It's go pull up Jim Desmond under Facebook. You'll find it that way.
Go to the website and you'll see.
Exactly.
Go to the website and click over. And Scott, if someone has a workers' compensation claim here in Kentucky, how can they get a hold of you?
Best way is probably call my office, which is 502-937-5287. I also have a website, Scheynost Law. You got to be able to spell Scheynost, SCHEYNOSTLAW.com. You can reach us on that.
And Scott, you also have a fairly active Facebook page for the office as well.
I do, yeah.
There you go.
Again, you got to be able to spell Scheynost. But if you can do that, you can find me. My number's in the phone book, and if you can't get a hold of me, leave a message. We'll get back with you as soon as possible.
All over the web as well. So, well, that's a wrap here for the Kentucky Auto Accident Podcast, episode number 8. And I want to appreciate you taking the time to listen. I hope this answered some questions. And if it raised some questions, well, that's not a bad thing either. Be sure to give either of these gentlemen a quick call, and they'll be more than happy to spend a little bit of time with you and help you figure out the best path for you moving forward. Once again, thanks for your time. We appreciate it. We'll talk to you again in about 2 weeks. That's it for this episode of the Kentucky Auto Accident Podcast. Jim Desmond will be back in 2 weeks to provide information you need to know related to car accidents and motorcycle wrecks in Kentucky. Until then, check out attorneydesmond.com. You can also follow him on Facebook at Attorney James Desmond. Drive safely, and please remember to buckle up.